Hello there, woven web enthusiasts. Today we have a story from the Idaho Supreme Court. A man's wife threatens to report to law enforcement he sexually assaulted their daughter if he doesn't deed their home to her. Ron Quiring had been married for nearly a decade. He arrived at his home one evening to find the locks changed on the doors. His wife then confronted him, claiming that he had sexually assaulted their daughter, a 15-year-old girl who was Lynn's biological daughter and whom Ron had adopted 5 years prior. Now, their marriage had been strained, and Lynn was attempting to coerce him into signing their home, a home Ron had owned prior to the marriage, over to her as part of their forthcoming divorce. His wife threatened him, saying she would report the alleged sexual assault to law enforcement and tell his employer. This is a tale, my friends, of a man making a series of bad decisions. His attempt to correct one of the mistakes required that he take his case all the way to the Idaho Supreme Court. The case is Quiring v. Quiring from 1997. Ron and Lynn Quiring were married in 1985 in Reno, Nevada. The couple divorced in August of 1995. Prior to their divorce, the couple had experienced marital discord and on 2 occasions separated. The final event precipitating their divorce occurred on July 11, 1994, when the couple's daughter, Lynn's natural daughter and Ron's adopted daughter, allegedly reported to Lynn that Ron had committed sexual improprieties with her 5 years prior. The record does not reveal the nature of these alleged improprieties. These events gave rise to a criminal indictment and charge, which was later dismissed. When Ron arrived at home on July 11, 1994, the locks had been changed. That evening, Lynn confronted him with the allegations of sexual improprieties. She presented a quitclaim deed for him to sign to the couple's community real property consisting of the family residence on Robinson Road. The Robinson property was originally Ron's separate property, but in May of 1990 he had quitclaimed the property to Lynn and him as their community property. The property was assessed in 1995 as having a fair market value of about $139,000. The debt against the property on August 17, 1994 was around $45,000. To obtain refinancing, the property was reappraised at $204,000 sometime after the couple separated. This amounts to equity of around $159,000. Ron claims that Lynn threatened she would inform the police and Ron's employer of the allegations if he refused to sign the quitclaim deed. Lynn denies that she made such a threat. Ron also claims that Lynn threatened that her father and her daughter's biological father would get Ron. Lynn also denies that she made this threat. Ron denied the allegations of sexual impropriety and left to spend the evening elsewhere without signing the quitclaim deed. The next day, Ron went to his job with Idaho Department of Health and Welfare, where he taught juveniles committed to secure confinement. He telephoned Lynn from work. According to Ron, Lynn told him that if he did not sign the quitclaim deed, she would have him arrested at his place of work. During breaks at work, Ron drafted a handwritten agreement with the following provisions. I do hereby relinquish interest in my residence located at 1009 North Robinson, Nampa, Idaho, for the following considerations. First, that any and all past differences be forgotten and not brought up by Lynn or either of the 2 children, a daughter age 15 and a son age 17. Second, that we part amicably with no further contact other than the details of the divorce. Third, there is to be, as agreed, no other compensation to be given by me in any form, including support for the children or my wife, as the amount of equity in the house shall be considered to be quite sufficient to more than compensate for any deficiency of support until the children reach the age where no further support is required. And finally, it is agreed between Ron and Lynn, husband and wife, that a divorce is pending and details of personal items within the house will be agreed upon separately. Ron telephoned his attorney and read the agreement to him. His attorney advised him not to sign anything. Ron then called Lynn and arranged to meet her and discuss their community debt and child support. After talking, they went to Stewart Title Company in Nampa. Ron presented Lynn with the agreement and told her that she would have to sign the agreement before he would sign the quitclaim deed. The parties read and signed the agreement in the presence of a notary. Ron also signed and had notarized the quitclaim deed conveying his interest in the Robinson property to Lynn. The quitclaim deed was recorded the next day. The deed listed $800 as the value received by Ron. Ron then filed for divorce on July 28, 1994, praying for a decree of divorce and that Lynn be awarded physical and legal custody of their daughter. And I'm going to break in and summarize here. In the divorce proceedings, Ron moved that the agreement and deed he previously signed be set aside while Lynn maintained both should stand. At the time of trial, Lynn had quit her job at Micron, which had paid approximately $1,200 per month, and had remarried. Ron had been fired as a teacher and was working on commission for Squat Down Manufacturing Corporation out of Anadarko, Oklahoma, but had yet to make a first sale. And breaking in again, in his efforts to have the agreement and deed removed or thrown out, Ron lost at both the lower court and in appeals court. Ron maintained they were not valid and binding, asserting that they were entered into upon undue influence, coercion, and duress. And now the decision from the Supreme Court of Idaho. The agreement and quitclaim deed are illegal and unenforceable. The agreement is unenforceable because it is against public policy in two respects. First, Lynn may not contract to refrain from informing law enforcement regarding the allegations of sexual improprieties with a child. According to the plain language of Idaho law, Lynn had a statutory duty to report the allegations. A contract provision obligating her to transgress this obligation is contrary to public policy. Second, obtaining the transfer of property by a threat of arrest or exposure to hatred, contempt, or ridicule is theft by extortion and violates Idaho state law. It makes no difference whether the threat of arrest was lawful or unlawful. Both the magistrate and the district judge found that Lynn had threatened Ron with arrest if he did not sign the quitclaim deed. It makes no difference whether the police were eventually notified of the alleged sexual improprieties or whether the allegation is ever publicly exposed. It also makes no difference whether the division of the property through means of extortion may in fact be an equitable division of the property. The agreement is illegal. Transfer of the quitclaim deed was premised on illegal consideration. The quitclaim deed was obtained through extortion, threats of violence, and public exposure to cause loss of employment. Illegal contracts are void. Accordingly, the magistrate's decision distributing property according to the agreement is reversed. The determination that Lynn acquired sole title of the Robinson property through the quitclaim deed is reversed. The case is remanded for an equitable division of the property and determination of child support. That is quite a case, and here are a few bullet points of the case. Lynn had a daughter when they got married. He adopted the child, the same child that allegedly made the sexual assault allegations against him. Lynn locked him out of his own home. Ron had owned this home prior to marrying her. They had $158,000 in equity in the home when he quitclaimed it to her. Ron went against the advice of his attorney. He quitclaimed the house and signed the agreement the day after she locked him out of the house and threatened him with the report of the alleged sexual assault. He acted hastily. Lynn was remarried by the time of the trial. In regards to employment, Ron was fired from his job. Lynn had quit her job. And finally, the sexual assault investigation was dropped against Ron. What are your thoughts on this case? Let us know what you think in the comments. And if you're enjoying the channel, hit that subscribe button. It certainly helps me out. I appreciate you listening.